Okay, so we'll wait for hopefully Dick and Matthew to join us. So they've got the links in 3 different formats, so one of them should work for them. So welcome to the October meeting of the PRC. All right, this is the first meeting we've had since Parliament resumed last month. So there's been a fair bit of activity in the bills department. But before we get there, I'll read the regrets. So Brendan has the regret for each of the meetings this fall due to his employment. Lynn has sent her regrets. Andrea has, Rob has, and John indicates that he'll be here, but he'll be late. All right. So when I see him come, I'll certainly admit him into the meeting. All right. So we have the agenda that was circulated on the weekend. So can I have a motion to approve the agenda?
Cool.
Peter, and have Howard as a seconder. All in favor? Thank you. Okay, and likewise, the minutes went out on the weekend as well for the September 12th meeting. So then again, can I have a motion to adopt the minutes as circulated? Oh, Stefan and Howard will be a seconder again. So thank you very much. All right, news and announcements. So we just have a couple here that I've inserted, and then we'll see if there's any more that we can glean from the press. So there's that perpetual one dealing with Peter and the Alberta government regarding the Alberta Police Service. And Peter, you gave us an update basically at the last meeting. Is there any? Do you want to keep this on the agenda?
Yeah, I would, because I'm working on it. In fact, I had a meeting this morning and was talking about that parts of it with somebody. So yeah, it's a work in progress that will be sooner than later.
Okay, very good. Here's Dick, so we'll allow him in. All right. Okay, let's keep going. I admitted Dick, so he should get here at some point. I've added this to the agenda. It should have probably been in last month's agenda as well. Over the course of the end of June and the beginning of the summer, Irving and Howard and I were dealing with a letter to the minister dealing with our position, or the CCGA's position, on the law of extradition in Canada. To some degree, it was a response to Hassad Diab's conviction and potential return to France, if that's going to happen. And I haven't heard anything more about that. So we did craft a letter. I didn't hear whether it was actually submitted on behalf of the board to the minister or not. Perhaps Irving or Howard would know that more than I would.
Yes, it went out.
Okay.
We haven't heard anything back.
Okay, fair enough. So I did.
Yeah, anyway. Yeah.
Thank you.
I did.
Welcome.
Welcome. All right, guys. All right. So there's nothing more to add to that. I'll keep it. I'll move it down into the next section, just because it'll be a waiting brief kind of thing. All right.
Just a sec, Miles.
Yes.
Miles, just worth noting that letter is on the website, so anyone can have a look at it. Along with another letter, we seem to have formed a little sub-working group, yourself, Irving, Peter, and myself. We did a letter also on the Bernardo issue, specifically indicating to the Minister of Public Safety and to the Prime Minister that their behavior was wanting in this, that they have an obligation to explain the law, not just pander to it. So both of those letters are on the website, and I think it's a good tool when time doesn't permit a full-blown brief to write these letters to the appropriate ministers, and these days copying to the Prime Minister so the PMO and others are aware of them. But they're good letters, I think, on both. Thanks to Peter and yourself, Miles, and Irving and I, we sort of toiled quickly to get them done after the last meeting in June. So anyway, worth noting, they're on the website for anyone who wants to have a look at them. Very good.
Yeah, thanks, Howard. And of course, I'll circulate the YouTube of this meeting afterwards, so anybody who watches this meeting will have that information as well. So that's terrific. Thank you very much. Any other news items that we want to add to our announcements? Recent news? Okay. All right. Business arising. So we'll move to the parliamentary committees. The first one is the Commons, Justice, and Human Rights. So that's Howard.
Thank you, Miles. So the Justice Committee has met 3 times since Parliament resumed in the fall. on September 26, October 3, and October 5. On the 26th, they elected a new chair. There's been some shuffling of chairs, so to speak, in the committee because of the shuffling of cabinet and a few other things. The person who was elected as chair is a woman by the name of Lena Metlege Diab. So she is a liberal, of course. The chair by standing order has to be a member of the government, so she's a liberal, and she represents Halifax West. From her own parliamentary website, she says this about herself, or someone says this about herself. She is Halifax West's first female MP, a past MLA in Nova Scotia, and provincial cabinet minister, lawyer, small business owner, grandmother, and longtime community volunteer. She's a very active participant of the Lebanese Canadian community on the East Coast. Notably, with respect to her, I was always curious to see what kind of background they have in criminal justice. She was a lawyer, but I think her lawyer activities were mostly in business, except that she ran for provincial politics, was elected, and served in cabinet. And roughly around 2013, she was the AG and Minister of Justice for Nova Scotia. So clearly she has acquired through that, she would get some exposure to criminal law and criminal justice issues. She seemed to go on from there to Labour and other provincial portfolios and did quite well. I don't remember her much as an AG at that time, but I'd already left the Department of Justice. So, you know, I may not have followed it closely, her tenure. One of the other things I wanted to note about the committee is there are two notable members from our perspective on it this time around. Marco Mendicino, the former Minister of Public Safety, who of course was summarily dumped from cabinet, but he is now serving on the Justice Committee, so his views and participation will be reflected in that. The other member of note is Anthony Housefather, again, someone who's found himself not in the good graces of the Prime Minister. And was recently dumped as a parliamentary secretary for taking a position contrary to Trudeau's position. But Anthony Housefather was the chair of the Justice Committee for a fair while. Irving and I, and actually some others, we had held a dinner in Ottawa and met with him. I think he's a pretty decent guy, and he's taken some pretty good positions over the years. As chair of the committee, they have to try and maintain a neutral balance and keep a consensus, particularly in a minority government. But I always thought he was a pretty decent guy. Irving, you had some conversations with him, I think, because you have some connections with Montreal and Quebec. But
I don't have any specific connections with him. It was just happened to be kind of serendipitously. His father used to be our notary like 50 years ago or 45 years. That was the only connection. He passed away a few years ago. But no, I don't have any ongoing connections with Anthony Housefather.
Anyway, his office seemed quite good and quite interested in some of what we were doing. So I just think in terms of on the committee, these days, often committee members do not have a lot of background in criminal justice. The two vice chairs Rob Moore has, but not the kind of background I find particularly helpful. But anyway, it's interesting, their new constituency, and we'll have to see what happens with that. Now, since Parliament resumed, and of course Parliament is adjourned this week because of presumably the Thanksgiving holiday returning next Monday, but they've been studying a bill. They actually in advance of second reading. So they have a particular phrase for it. They've been pre-studying or studying the subject matter of Bill S12. The reason for that is S12, there's a time clock running on it. You may recall that S12 is the government's response to a Supreme Court of Canada decision in 2022 called Regina versus, and pardon me if my pronunciation is not accurate, but Nedlovu. At any rate, it's a 2022 decision of the Supreme Court of Canada where they struck down parts of the sex offender registry. Now, this is not an area that I've followed closely or know a lot about, but the Supreme Court struck down some of the mandatory listings and lifetime listings as contravening Section 7 of the Charter. They gave the government a year to respond, i.e. to enact new legislation, and that year is over as of October the 28th. Okay, so this bill S12, obviously it is a government bill, not a private member's bill, but it was introduced in the Senate. It has passed through the Senate. The standing committee did pre-study of it, although as of October the 5th, the bill was actually sent to them. It was passed second reading and was sent to them. So the committee's website indicates they have no meetings scheduled, but their business discussion on October 3rd indicated they're planning a meeting for October the 17th to continue hearing witnesses on this. But the clock is running. I don't see this as something that PRC has much chance to intervene. I think the government will pull out all the stops to pass this bill before or by October the 28th. The bill itself is described in the agenda for today's meeting on about page 10. So you can take a look at that at your leisure. In addition to the issues of the lifetime ban and the mandatory nature of the registration, they've moderated those and focused those more on sexual offenses against a child and cases where there are two or more offenses. And they've dealt a little bit with the NCR verdict. They've also actually touched on that bill on the issue of revoking publication bans. You may recall there was a little bit of a controversy that some victims did not want to be covered by a publication ban. Let me say victims of sexual offenses. They didn't want the publication ban to prevent them from coming out and saying what had happened to them. And in many cases, the Crown and the courts were just as of right, that's the wrong word, not as of right, but regularly without discussion imposing the publication bans. And some victims of sexual assault were upset about that because it limited their ability to speak about what had happened to them. So there's a few amendments in S12 on that, a very light touch. But of course, there's a recent Supreme Court of Canada decision again talking about publication bans in the context of jury trials. I don't know how all of this is going to mix together, but my guess is S12 will move very quickly. So not much of a chance for us to wade in on any part of that. But I think that's all for my report. Miles, any questions or comments? I'm happy to entertain.
Sure. Questions, comments, anyone?
I have a quick question. I may be out of date a bit, but Howard, am I correct that that committee is not having hearings on the bail reform proposals?
Yeah, it's I had not planned on talking about this because that bill C-48 is now before the Senate committee, and I thought Brendan might be chatting about that.
Oh, okay.
But it is absolutely true, and something that I have never witnessed in over 40 years as a member of the Ontario Bar and 27 odd years at the Department of Justice. There was kind of a second reading debate on the bail bill C-48. And when I say kind of, there was a lot of self-serving statements by the minister, questions to the minister from his own parliamentary secretary and other liberals. All of the positions stated their position, and they quoted at some length in second reading the opinion, not of the chiefs of police, but the police associations across the country, which have been pushing for more people being held in custody pre-trial. The bill jumped from second reading right out of the House. So there was no consideration by committee. There was no report stage. There was no third reading. There was literally no review of the bill. It has gone into the Senate, and the Senate committee is pulling it apart. And the Senate committee the Senate committee has an opportunity to propose some amendments. They're hearing some decent witnesses on it. That's ongoing. Senator Kim Pate has joined the Senate committee for those deliberations. So there's some interesting stuff going on there. But of course, we know the Senate, Richard, you and I know all too well, the Senate is reluctant to spit in the face of the House. And the speed with which they pass this, the Minister of Justice has been was quoted actually in the Senate committee hearings as having said, well, I am sure this will increase public safety. I can't tell you how. I don't have data on it, but I'm sure it will. And I had put one of those clippings in the newsletter a week ago. The government has seemed intent on passing this, I think, partially to appease the provincial territorial AGs who are unanimously in support of it, and the police associations. They don't seem to be listening to any of the groups, the voice of which is increasing that this bill will exacerbate a problem that already exists. But yeah, no, Dick, it just jumped from this posturing at second reading right on through out of the House. I've never seen that before. I've seen the House form as a committee of the whole and have a consideration in the whole House as a committee consideration of the bill. But this is what I can only regard as undemocratic. I know that's a strong word, but they blocked all debate in the House, all review and study of it. They don't control the Senate, but I'm sure the Senate will be reluctant to amend the bill and send it back to the House, given the pressure and the steam that's been built up on this matter. But it's not a good bill. It's a small, focused, and kind of nasty bill, and they're attempting to up the argument to accord with Supreme Court of Canada case law that says reverse onus and bail is not unconstitutional provided it's connected with public safety. So the bill talks about, repeat offenders, but of course they don't mention the fact that you're not a repeat offender until you're convicted of the second offense. So you're in fact not a repeat offender. You've been convicted of a similar offense in the past, but charged with it. And if you're not a repeat offender, you're not an offender at all if this is the first time you've been charged. None of that logic seems to have stuck with the government. So Miles, Brendan's not here. I wouldn't have gone into this length, but the Senate committee is looking at the bill. I suppose at this point they're studying it for the record to try and get on the record. One of the real problems with the way the House dealt with the bill is that courts have been more inclined in the last 2 decades to look at the parliamentary record to understand the intent of the bill when there was a charter challenge to it. The government effectively has eliminated anything but some speeches at second reading in the House, but there will be some committee proceedings in the Senate that courts can look at when C-48 provisions are challenged, as I presume they will be. But it's a matter. If I had hair, I'd be pulling some of it out. So
Thanks,
Thanks,
Howard.
Howard. I was wondering if CCJA has had any input in this process. Being new to this whole process, I just don't know.
The answer is no. We haven't had anybody prepare a brief in that regard, and nothing has been forwarded by the PRC to the board. And at this, it's a good question, Dick. But at this stage, it's moot to a great degree. There's nothing that we can do that's going to change the course of where this bill is heading.
Right,
Dick, if I may, I was shocked. This was the first day back, right, from the success that they did this. Was occasion that the new minister had met with Kath Latimer and us at CCLA the Friday before. I had never mentioned to them that they were going to post procedural. CCLA, John Howard, I think he as well, others met with the minister and rushing against this reform. I have two pro bono students who will be working with me this fall. One of them this term, last year, interested in bail, and we've working towards a sort of a research group. I had said to her before I had a Zoom paper on C-40.
Howard is breaking up. I can't understand him.
Yeah, I was hoping that was going to correct itself, but the last minute or so, Howard, we couldn't get what you were saying. It was and your picture's freezing as well. So he's going to come back in, I presume. All right, well, let's carry on. Howard, I'm sure, is going to come back in, but that finishes his report on the Justice and Human Rights Committee. The next committee is that of the Public Safety and National Security. That's Rob. Rob is gave us his regrets for today's meeting, so he sent me the report in that regard. So I'll read it to you. It's quite short. So as for SECU, I checked the SECU website and noted 2 meetings, one on September 27th, where they elected 2 new vice chairs, and went on to decide to have 2 future meetings to examine the Bernardo transfer to a medium security institution. The second meeting took place on October 4th and involved further examination of Bill C-20 by way of testimony from public servants from DPS, RCMP, and the CVSA. No evidence was available as of today. Okay, so that's just a pretty straightforward report. So we'll take that, we'll accept that as read. The next committee is now to the Senate, the Legal and Constitutional Affairs Committee.
Miles?
Yes.
May I kindly interrupt for
Sure.
the question for Irving? Irving, does the CCJA, since there's a parliamentary hearing potentially scheduled, does the CCJA ever get involved in matters like the Bernardo transfer?
Well, Matthew, we wrote to the minister about it. It's on our website.
Okay, thank you.
So you can go to the website, you can read the letter. Okay.
Good. Thanks, Irving. Thanks, Matthew. Okay, so Brendan, again, he's away, but he's, as is wont of Brendan, he's very studious in providing us with his report. It deals with Bill S-212 and Bill C-48. Bill C-48, the one that Howard just went into at some great length, so we don't necessarily have to repeat that. But here's Brendan's report. This is a report to the PRC and the activities of the Standing Senate Committee on Legal and Constitutional Affairs. The committee has met 6 times since Parliament returned in September. They have met twice to discuss Bill S-12 and 4 times to discuss Bill C-48. So Bill S-12. This is Senator Pate's private member bill to create an automatic record expungement system. We have reviewed the activities of this bill several times earlier in the year, so I will not discuss it in too much depth. The committee saw several more witnesses, such from organizations as Elizabeth Fry, St. Leonard's, Aboriginal Legal Services. They then proceeded to do a clause-by-clause review. The bill passed substantially in its original form, save for some amendments passed by Senator Pate. 1, some amendments were technical and simply a change of wording. The senators agreed this did not change anything of substance. 2, the major amendment was in response to concerns from the policing community. It no longer requires ministerial review to release records related to unpaid fines and victim surcharges when there are concerns from police about the interests of the administration of justice or the safety or security of Canadians and its allies. My assumption is, this will be Brendan's assumption, is that this was a change to garner some support from senators who had reservations about the bill. A report was tabled in the Senate awaiting 3rd reading. So that's good. That's obviously good news. We support this bill the way it is for the most part. Having said that, it's proceeding. So that's interesting. Bill C-48, Brendan's given us a couple of pages on that. I'm not going to repeat it. It's encapsulated by what Howard had to say to a great degree. So again, Bill C-48 is moving quickly towards assent. So we'll leave it at that unless anybody has any questions, or do you want me to read Brendan's report into the record?
Is it lengthy?
It's a couple of pages. It's
You don't need to read it in then.
Okay. Yeah, but he's not saying, he's providing more particularity with respect to who appeared before the committee and what have you, and I get that, and the individual opinions of those who appeared pro and not very much against the tenure of the bill. So again, Howard covered it nicely in his report. So we'll leave it at that. Okay, thank you,
Miles.
Yes,
Miles. If you want to just forward that to me,
yeah,
I can praise it and add it to the minutes as just as like an appendix to the minutes, so that people can get a bit more of a flavor if they want it.
Absolutely. Thanks, Peter. I'll do that.
Okay, thank you.
Yeah, thank you. Okay, that's our reports from the committees. The next item is on the Canadian Cases Review Commission report, which is now the Miscarriages of Justice Commission, which is before Parliament in Bill C-40. And we discussed this last month that I would prepare a brief for the PRC and the CCGA, putting forward the prospect that this particular commission, once it's enacted, if it's enacted, should have provisions in it dealing with compensation. Or there's Howard, hang on a second. So as we discussed last meeting, and was at Matthew's behest, I've already started preparing a draft report with respect to this committee work. I've also made a request to the secretary of the committee to personally appear before the committee when it actually has resumed its meetings for the purposes of its studies. And and if they accept my request, then I'll have the brief prepared. I'll circulate it obviously to the PRC and the CCGA, and then make a presentation to Parliament or to the committee when the invitation is extended, if it's extended. You know, you never know, but I've certainly made that request to the secretary of the committee. Any questions about that?
Thank you, Miles.
You're welcome, Matthew. Thank you. All right. Item number 7. This is a perennial kind of thing. This is back at you, Matthew. This is the letter that you and Kyle were to draft to the Minister of Public Safety, dealing with the historical positions of the CCGA on alternatives to incarceration. So it's been on our agenda for quite a while. Is there something that's going to come of that, or should we take it off the agenda?
No, I want you to keep prodding me.
Not a problem. All right, we'll leave it for that. Next on the agenda, there's an update to this from last month. So this is item G, dealing with the proposal put forward that we would basically promote the amalgamation of the provisions in the provinces and territories and the federal government under their various human rights codes, so that a criminal record would be a protected ground of discrimination with respect to employment and with respect to housing. And the housing was added actually at the meeting that I had with the two gentlemen from the Uniform Law Conference of Canada. We had a very, very fruitful conversation last month. They're quite keen on this. They thought it was quite appropriate for the ULCC to take on. And so what they're going to do is they're going to work on the logistics of getting it in front of the conference, basically because they saw it as both something that should be handled and endorsed by both the criminal law section and the civil law section of the ULCC, which are the two sections that it deals with reform. So they were quite positive. I was quite pleased with the tenor of the conversation. So is there anything I can tell anybody about that in further detail?
Miles, do we need to monitor this particular project?
Well, I mean, I'm on it. I'm monitoring it as far as that goes. I mean, it's at this stage of the game. I expect that once the logistics have been worked out internally with the conference, then they will get back to me. And they also indicated that their desire would be to have, and it doesn't have to be me, but they suggested that I would be a delegate to the discussions that take place internally. So that's great. I'd be more than happy to do that. So that's where it stands. So we are monitoring it by virtue of my participation in this process. So obviously every time each month we return back to the PRC meetings, I'll provide updates on what's happening with it. But at this stage, it looks positive. It's the two gentlemen I talked to. They don't have obviously the weight to put it forward themselves and endorse it themselves. It has to go to their board. But they're certainly going to promote it for inclusion in their agenda. So that's a good thing. Yes, Howard.
Miles, I think, there's some details that we need to sort of chat a little bit about before it goes too much further. I think going to the Uniform Law Conference, they'll hold a joint session, what they call a joint session of criminal and civil, and it has a foot in both camps. I think it's a wonderful thing to add housing. Employment and housing are important. It's hard to tell which is more important, but without housing, everything else is kind of lost. The difficulty we may have is when do we want the prohibition of discrimination to kick in? In Ontario, for instance, it's only after a pardon or a record suspension has been issued. If that's the trigger, that makes some sense logically, but it would have to be for both. And so that the prohibition on discrimination in the Human Rights Act would not apply until someone had applied under the federal legislation and received a record suspension with the current waiting periods and all of that. We'll remember that we had a long conversation about this in a previous draft, and we're not able to arrive at consensus with the board about when relief from the criminal record should occur. So should we be waiting for the federal application and granting? Should we establish our own time periods? Someone like Kim Pate would want to see the record sunsetted, the effects of the record, and hence no discrimination thereafter much earlier than the federal legislation would allow. But we had some difficult conversations at the PRC and then at the board, with the board not being prepared to go as far as some of us had recommended in terms of automatic sunsetting of records and that sort of thing. This is kind of another kick at that can. A prohibition on discrimination would not amount to an automatic sunsetting of that record for all purposes, but would be roughly similar if there was a prohibition in every province and territory on discrimination with respect to employment and housing. So we need to think a little bit about when the prohibition, what we're going to recommend with respect to when the prohibition on discrimination would take effect, sort of thing.
Well, we're with all due respect, that's conflating Bill S-212 and this proposal. So the way that the brief was prepared, that I prepared and put before the PRC previously, it basically set out, the 5 jurisdictions, including Ontario, that requires a record suspension or what was a pardon for anything to happen. And there are another 4 or 5 jurisdictions that the trigger, doesn't require a record suspension. That doesn't require that at all. It simply requires, it simply sets out that anybody who is applying for a job, and there's no reference to housing anywhere in any of the human rights codes. Anybody who's applying for a job, as long as their criminal record doesn't pertain to the particulars of that job, is entitled to the protection of the Human Rights Code with respect to discrimination relating to criminal records. So there is no sunsetting of a record involved in that, or an expungement of a record involved in that by virtue of whatever Kim Pate's bill may well do. It applies right off the hop, and it fills a tremendous gap in that no longer those persons with criminal records, once they've served their sentence, they no longer have to wait either 3, 5, or 5 or 10 years, depending on what the time frame is going to be. And Kim Pate's bill is 3 years and 5 years based on summary conviction and indictable offenses. Nobody has to wait that period of time for their record to in her case automatically be expunged as a spent conviction. So at least the position that was discussed when I had this conversation with the gentleman at the conference was that it was along the lines of those jurisdictions that basically, virtually as a function of somebody having a conviction, would not have it adversely affect them with respect to employment, as long as the conviction didn't deal with the type of employment they were seeking. So, I'm trying to just be clear that when the conversation took place, and again, if the PRC wants me to back up on this position, I have no problem with that. But the position is that we're taking the position that 4 or 5 jurisdictions already do that. Like, for instance, British Columbia. British Columbia doesn't require any sunsetting of the conviction or any period of time to pass. It just simply says, if in the Human Rights Code, basically says, if somebody's applying for a job and their criminal record does not pertain to the particulars of that job, the employer cannot use the conviction against them in the employment process. There's 4 or 5 jurisdictions that do that. And that is the model that we were talking about during the course of the conversation. And then we added housing likewise. So, and that would basically be, that, once somebody has has been convicted, has served their sentence, then they can if it was basically amalgamated across the country and in a uniform fashion, that somebody applying for housing from the day after their sentence is served can seek housing, and their record would not be held against them in that regard. There are things that still carry forward from all the discussions that the CCJ has had regarding those with records relating to sexual offenses and child pornography and all those kind of things. That protection is not eliminated whatsoever. I mean, those are issues that will always be there, and for the most part would be exempted from any automatic discrimination based on a record. And that would have to be built into the criminal code or the human rights codes as they go forward. But and so just to be clear, so what we're talking about here, at least at this stage, is once somebody has served their sentence, then that record will not harm them with respect to their employment prospects or their housing.
Question, Miles.
Sure.
We have a sizable number of people serving life, some for drug offenses, but more common for manslaughter, murder in the second, murder in the first. What do you say about those individuals whose sentences never end, whether they're inside or on conditional release?
That's a good question, Matthew. In theory, their criminal record, no matter what the offense, unless it's a specifically identified offense, would not be held against them.
But Matthew's question is even broader than that.
Right.
When does the sentence end? Right? Are you talking about warrant expiry? What about someone who's released from a penitentiary sentence and on day parole or on full parole? When does I think our position needs to be very clear. I'm not arguing against doing it automatically, but it's a lot like an automatic sunset of a record. If it's on release from prison, that's one thing. If it's on warrant expiry, that's another. If it's after a period of time after warrant expiry or release from prison. And we also need to have some clarity about what we mean when we say it's not related to the job. So if it's, for instance, a conviction for fraud, and the job involves any kind of fiduciary relationship, not even necessarily financial, but involved in a company where somebody might have access to. I think we just need to be clear about what we're talking about. I'm not opposed to an automatic prohibition of discrimination for employment and for housing, but already we have the limit on employment unrelated to what the employment they're seeking when the record isn't related. So I think we need some clarity. And Matthew's point about a life sentence is a very good one. They shouldn't be excluded from the discrimination. So we have to have a definition that's something other than warrant expiry or ending of the sentence or release. Someone's even out on day parole, they may not want to live in a halfway house. We've seen recently how crowded halfway houses are and that sort of thing. But if they are subject to discrimination by a landlord because of their criminal status. So Miles, my only point really is this immediately gets into the notion logically of sunsetting of the record at a period of time, that it, for certain purposes, it no longer has effect automatically. I actually like that idea, but I caution in two things. One, we need to be very clear on what we're proposing. And Miles, what you've just outlined is entirely opposite to what Ontario does. It's very different. So Ontario will have a hard time coming back from that. But we need to be clear about that. We need to think about the implications. And so what does it mean to apply for a job as to whether or not it's related to your criminal conviction? Some employers will say you've been dishonest, you've committed an offense. So no matter what the conviction is, it's inconsistent with the employer-employee relationship. All I'm saying is I think we need to be very clear up front on this, and I'd love to see us have that conversation. So,
well, those are excellent points. I mean, this is very early days, in this process, and I think I think we should, have that conversation and more. And you would know better than I would, Howard. I mean, so, on the premise, and this is all we have, is this premise that these gentlemen I talked to liked the prospect of what was being proposed, that there be, a uniform position across the country dealing with the application of criminal records against harmful effects against employment and housing. So what is the process? And I don't know this, of the conference. What do they do? How do they do this? Do they study it? Do they ask for reports or delegations? I mean, what is the process?
Well, it's been a while since I was involved. I was many years ago the secretary of the criminal law section, and then for a couple of years I was the head of the federal delegation. The people you're talking to are the secretariat for the Uniform Law Conference, and of course there's a president, and the president is elected by the conference. In this particular case, because it would be a submission to both sides of the conference, they would seek agreement from the president of the head of the civil side, and the head of the criminal side, and delegations would have a chance to say whether they want to get involved in this. I mean, we could, and it won't happen quickly. We'd be lucky if it comes on for next year, but there'll be the secretariat people that you're dealing with will have to talk to the feds and all of the provincial territorial jurisdictions, and whoever's elected is president of the conference for the year in question, to see if they're interested in taking this on. We could actually advocate simply for uniformity, whatever that may be. But they may opt for uniformity at the Ontario level, which again would be only subsequent. The prohibition on discrimination will kick in only subsequent to the record suspension, which arguably would take some jurisdictions in a backward direction. So again, I think we need to be clear about what we're advocating for. I think we'd be lucky to get it on for next year, but it is possible. Uniformity is something the conference will support no matter what. But then the question is uniformity at what level? And I don't think we would want to see the protection go backwards in some jurisdictions. I don't think we want everyone to adopt the Ontario view, given how long it takes with the waiting periods for the federal legislation and the application process. I like the idea of automatic suspension, but I mean, we'd have to talk about whether it's release from prison or warrant expiry, and if warrant expiry, how that affects life sentences. Matthew's right, murder, manslaughter, there's some drug offenses that have resulted in life sentences as well. Life not as a mandatory or a minimum. But we just want to be clear about that. I think at this point, Miles, you're absolutely right. It's great to see the enthusiasm of the Secretariat, whether that extends to the civil and the criminal law side, which are mostly government kinds of people, we don't know yet. But a proposal for uniformity is hard to say no to, period. But the question is, at what level are we unifying? And that's the devil's in those details. And I think we want to be pushing for a progressive approach, but one that's fairly clear in its implications. So anyway, I as you know, I've pushed and supported this. I'm glad you've been in touch with ULC, and it's been years since I was there. It's a long and slow process. It's a little bit like a UN process because it involves every government in the country. So they have to get some consensus about this. I think there might be some interest without much controversy about unifying, but again, if we don't want the unification, the cross-country unified position to be a retrogressive step for the 4 or 5 jurisdictions that start presumably at warrant expiry or release from prison. So it's more complicated than it looks on its face, and the devil are in the details. Miles, I would suggest in an upcoming meeting we have kind of a conversation about when we think as the PRC the prohibition on discrimination should kick in. I'd be happy to support at warrant expiry with a special tie-in for life sentences, or even on release, because when you're released from penitentiary or provincial prison, you need to find housing and you need to get a job. Those are essential steps to rehabilitation. So, but you know, I just think we have to be clear in our own mind. It's in the end, it's a lot like automatic sunsetting for those purposes of the criminal records. The criminal record limitations would still exist for traveling, for various kinds of activities, volunteering, foster parents, that sort of thing. But anyway, we need to think about all of the details of the issue, and I support a conversation, maybe most of a meeting devoted to this kind of thing. And remember, just we had some trouble. You and I supported the Kim Pate model, but we didn't get full support at the PRC, and we certainly did not get full support at the board. So just so people understand the whole background to it.
Absolutely. Thank you. That's terrific. Thank you. I absolutely great. I understand all of that. I think that's a good idea. So let's leave it where it is now at this stage of the game. And then as we move forward, we'll see if we can fix a time where we can actually, put our minds together to come up with a position that we're all happy with, or most of us are happy with, that we can take back at the appropriate time to the conference. Yeah.
Miles.
Yes.
Oh, I'm sorry. Can I put in 5 seconds worth?
Absolutely. Yeah.
I see this getting far too convoluted. What we originally proposed was that we have a uniform position across the country. And if Ontario wants to be the odd person out, well, too bad for them. But we're going to push for the uniform focus by everybody, and how that happens is one thing or another. But that's our stand. It has to be uniform. The second piece is we just talk about criminal record. So whether you're a lifer or you just got out, you had 30-day sentence, you had a conditional discharge. If you have a criminal record, you get a criminal record when the judge says you're convicted. That begins your criminal record. Okay, albeit 30 days later after the appeal. After the appeal time period is done, and you've been charged and convicted, you have a criminal record, I think. Unless I'm really far wrong here. That's what we're talking about. And so if we say the criminal record, regardless of what the criminal record is, if you have one, it can't be used in a discriminatory manner against you if it's for employment or housing, unless there's a nexus between your record and the employment and or the housing. And that, to my mind, is simply the position that we're putting forward. And I understand the complexities down the road, right? I think sometimes that we're sort of putting too much in the soup when all we want to do is serve a consomme. So that's my opinion. Thanks.
Peter.
So Peter, just to question that, so the moment the sentence is imposed, the prohibition applies, whether they've served the sentence or not, whether they paid the fine or not, whether their probation is or their conditional sentences over or not. It would take effect the moment the sentence is imposed.
As soon as they have a criminal record, and I would bow to your knowledge more as to what, the moment that occurs, to my knowledge, I don't have a criminal record. When I do get one, then this thing or this process would kick in. So as soon as you have, whether you finished your sentence, not finished your sentence, I can't remember if it was Matthew or yourself brought up about, someone from a halfway house seeking another place to live. Okay. The record, they have a record. And so is their record something that can you have a nexus between their record and where they want to live? And if you can't find that nexus as to why they cannot go and live there, for example, even the worst sex offender should not be housed in the daycare. And so, there's a clear nexus that way. You brought up about the fraud. If you're going to work as a bank teller, all right, I think that there is a nexus there. I really do. And then, but when you look at the criminal record, it's what is the record about? What is it? What is the nature of the crime? That's the piece that we want. But when it comes into play, from my thinking, for what we're trying to propose here, is that as soon as you've got a criminal record, and we can figure out and spell out what we mean by that, then this kicks in, and it cannot be used against you when you're applying for housing or employment. And that's the way I see it.
Thanks, Peter. I mean, that's great. That's part of the conversation, and it's a good piece. So I appreciate that.
Okay.
Well, a very clear and well-articulated position. Some of the response by some people will say, well, if you haven't served your sentence, then you haven't paid your debt to society. So that all of the negative attributes of a conviction shouldn't be waived the moment the record starts the moment the conviction is entered. That's what the criminal record is, and the rest of it is a question of who keeps it and who has it. So there's a lot of mythology about what a criminal record is, but the moment the conviction is entered. But Peter, I think the response to your position might be, until you've paid your debt, until you've served your sentence, why should you be relieved of all of the consequences or the important consequences of your criminal behavior? Now, I think there are some answers to that, which are because we want the people to be housed and employed where necessary. So, Peter, I think your articulation is clear and logical and very laudable, and I think I'd be prepared to support it. But there will people who'll say, then you're saying that there's no negative consequence from being convicted of criminal offense right from the get-go. So anyway, that will be the response. But Peter, I like your position. So,
and Howard, I really like the point you made with respect to getting employment and housing as part of your rehabilitation. I've seen in parole certificates where they talk about the quote inmate. One of the conditions being that they seek and maintain employment. So if you're putting these roadblocks on that, and you're talking about parole, that might even be a bar to some people, some inmates getting out because they have a record, and in terms of what their plans are in terms of employment, might not be realistic because of the Human Rights Code saying, well, you've got a record, so you can't work in these type of jobs. So that might close a lot of doors and really threaten the chance of getting parole. So.
Good, thank you. Again, we'll come back to it. And Howard's quite correct. When I was talking to the gentleman, they said that we would be lucky to have this before the conference next summer, which is the next time they're all together and what have you. But they said they were hopeful that would take place. But again, it's the timing of it isn't necessarily in their hands. So anyway, it's not going to happen overnight, and they don't necessarily need us to have a concrete position by tomorrow, kind of thing. So we'll form a position and convey it appropriately, I think.
And my one caution is really we just need to be really clear on what the position is. Peter articulated it extremely well. We need to be open about that so the board members and all PRC members understand. But I think Peter's already done a wonderful job at articulating that. So
yeah, I totally agree. So thank you. All right, guys, that's it for Business Rising. So next we have bills under consideration. Based upon the time, I think we could touch on those that are public as opposed to private, unless you want me to go any further than that. But in the Commons, Bill C9 has now had royal assent. That's the bill that amends the Judges Act with respect to monitoring their behavior and all those kind of good things. So that was received royal assent on the 22nd of June. So it's now law. Bill C21 received second reading on June 21st. And that's a bill that has a number of enactments dealing with increasing maximum sentences from 10 to 14 years for weapons charges and the kind of deeming certain firearms be prohibited and what have you. So it's moving along. So it'll be a committee shortly, I would think. Bill C41 has had third reading and now royal assent. So this is the bill that basically indicates that it amends the criminal code in order to create a regime under which the Minister of Public Safety and Emergency Preparedness may authorize an eligible person to carry out in a geographic area that is controlled by a terrorist group and for certain purposes, activities that otherwise would be prohibited. This was we've talked about this previously. This was the result of the Senate Human Rights Committee report that certain groups, for instance, the Red Cross, if they're being funded in Afghanistan, would be seen as assisting a criminal organization to some degree and would lead to charges. And this bill was to address that, to make sure that, in fact, money could flow to beneficial parties in places like Afghanistan, where some good can be done without the environment in which the criminal code was previously. Any comments about that? All right. And with respect to the Senate government bills, Howard's already made reference to S12. And apart from that, you can go to the agenda. So there's a number of there are a number of private bills that are there. I just touch on the ones that have been introduced as opposed to simply moving along the chain. So Bill Bill C342 was an act to amend the Corrections and Correctional Release Act, basically to require that inmates who have been found to be dangerous offenders or convicted of more than one first-degree murder be assigned a security classification of maximum and confined in a maximum security penitentiary. And that's also repeated.
Who is the author of that piece of legislation?
I don't have it in front of me. You'd have to go to legislative information site, Matthew. It's the bill is repeated at Bill C351 as well, exactly the same thing. This is Bernardo. This is the thinking behind it. But if you go online and go to the federal site for legislation, you'll see who put it forward. I didn't record that, so it's something. It'll just take a couple of seconds to review. Anyway, it received first reading on June the 14th, and Bill C351 received first reading on September the 18th. I honestly don't understand it. The wording is identical, so I understand why there's two separate bills being put forward, but maybe I've missed something in the text of them. Bill C350 has been put forward. It's an act to amend the State Immunity Act in the Criminal Code and the Immigration and Refugee Protection Act. It's a long preamble. The enactment amends the State Immunity Act to provide that a foreign state that supports or has supported torture or extrajudicial killing is not immune from the jurisdiction of any court in Canada. It also amends the act to require the Minister of Foreign Affairs to respond within a specified period to report of the parliamentary committee that recommends restricting the immunity of a foreign state under the act. Is there a story behind this? I didn't recognize any news item that would have prompted this. So, but it was introduced at first reading on June 21st. Yeah. And lastly, Bill C353 was introduced on September the 19th, an act to provide for the imposition of restrictive measures against foreign hostage takers and those who practice arbitrary detention in state-to-state relations, and to make related amendments to the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. So that act authorizes the government of Canada to take restrictive measures against foreign nationals, foreign states, and foreign entities that engage in hostage-taking or arbitrary detention in state-to-state relations of Canadians or eligible protected persons outside of Canada. Does that ring a bell? Again, I don't recognize the news, that item that may well have prompted that.
There was some old news. Forget her name. She was actually from Alberta. A journalist who was held in situations that could potentially fall under, but like we're talking what, 2 years, 3 years ago. Okay. It's not new news by any stretch. Okay. All right.
Anything else? And lastly, there are two new private member bills in the Senate, S267, an act in the Criminal Code to provide that taking advantage of the fact that a place is under an evacuation order or is experiencing a natural disaster or emergency is to be considered an aggravating circumstance for sentencing. So
I'd say that comes out of the whole issue of all the evacuations that have occurred because of the fires out west here and Northwest Territories. And that actually, to my mind, makes perfectly good sense to bring in.
Well, that would,
but I think that was the genesis of that. Yeah. I don't know for sure, but that would be my assumption.
No, that makes all kinds of sense from a context point of view. So, thanks, Peter.
Well, historically, CCJA has been reticent to add aggravating circumstances like this to sentencing. It contributes to over-incarceration, among other issues.
Did you want to do something about that, Matthew?
Well, I already have one foot in the mud pile for not drafting the letters. You better take it easy on the old guy.
All right. Does anyone see this as worthy of a brief?
Only a brief to support it from my standpoint.
I think I'd rather write a brief against the silly Bernardo nonsense.
Well, you're welcome to. I mean, we encourage that. I mean, read the letter that's on the website first, Matthew, and then come back to us next month to see whether you want to add something, because
Okay.
it's certainly available to you. And the last piece is there's a new bill S628 to amend the Criminal Code and the Indian Act. The amends section 207 of the Criminal Code to provide that the governing body of a First Nation has exclusive authority to conduct and manage a lottery scheme on its reserve and to license the conduct and management of a lottery scheme by other persons and entities on the reserve if the governing body of the First Nation, which is going to be the council, has provided notice to the government of Canada and the government of any province which the reserve is located of its intention to exercise that authority. So it's not criminal justice. Peripherally it is because it's regulated by the code, but there we go. So if somebody wants to run a lottery. All right, guys, that's it for the business and the bills. Does anybody have anything else to add to the meeting before we adjourn?
Miles, may I be recorded as present for the meeting, even though I missed the first 20 minutes?
Peter?
I had technical difficulties.
Yeah, no problem at all. Peter will record that in the minutes of court.
And Irving, the powers that be, let me attend the Kingston pre-release fair.
The what?
The Kingston pre-release fair.
You want to be released in Kingston? Is that what you're saying? I'm not aware of what you're referring to. I'm sorry.
I wish that, well, that would be most interesting. I'm not sure the keepers would want to have me kept. I would be regarded as too litigious.
Litigious.
Yes, but what I'm saying is that I finally got accepted and attended the Kingston pre-release fair for.
Oh, this is what you were referring to a couple of months ago, I think.
Right, and
how did it go?
I got in. I was extremely cordial with all the staff. It went well.
I'm glad.
We'll
and they
see.
let you go home?
They even let me go home. I was amazed.
You're making progress, Matthew.
Well, I tell them I know people in high places.
You may know people in low places as well, Matt, knowing your history.
All right, guys. Anything else for the good of the meeting? Okay, I apologize. I didn't wish everybody a happy Thanksgiving weekend. Hopefully, everybody had a lovely weekend. And we will see you next month. I believe the date is going to be November the 14th.
Take care.
Thank you, everybody. Take care. Bye now.
Stay healthy. Bye-bye.